Let's say I'm in a deposition as a client, right? What am I allowed to say? What am I not allowed to say? How should I be answering those questions? Welcome to the Biker Rebellion. I'm your host, Ginger, here with founding member of the Biker Lawyers, Pete Leahy. Today, we tackle depositions, covering what you should expect, how to prepare, and more. First off, what is a deposition, and when do these occur in a personal injury case?
A deposition is sworn testimony. By sworn, I mean you take an oath, just like you see in a courtroom. You take an oath to tell the truth, and then the opposing lawyer is going to ask you a series of questions, at least supposedly about the case. It's an opportunity for the other lawyer to find out more about you and about your case.
How does it work? Who all is there? And what role does everyone have in a deposition?
I'll talk like it's one that I'm involved in with one of my clients.
Sure.
So it's going to be my client and me on one side of the table. The other side of the table is going to be the insurance lawyer. Maybe the insurance lawyer has a representative of the insurance company with them. And then there's going to be a shorthand reporter to take it all down.
Okay. And do you object to questions often? When do you object, and why do you object?
When to object? I object to questions and depositions approximately every 5 or 10 years. I was saying that kind of tongue-in-cheek, but I mean, I am serious. I almost never object in a deposition because the standard for what you can go into in a deposition is so extremely broad that almost every objection you hear in a deposition is just bullshit. It's being given for some reason other than a legitimate objection. Depositions aren't the place for objections like you hear in a courtroom. It's not objection irrelevant. You're not supposed to do that in a deposition. More often than not, if somebody objects, and I'm talking about the guy on the other side, defense lawyers,
Sure.
More often than not, I think they're doing it either to give cues to their client or to try to disrupt my flow. And I don't mean to say every insurance lawyer does this because there are a lot of really good insurance lawyers that I deal with, but are there lawyers out there that do that? Yeah, absolutely.
So it's more of a tactic rather than a legal strategy when they're objecting most of the time.
In my semi-humble opinion, yes.
Fair enough. Now, let's talk about what being under oath means. I know there's plenty of people in the audience that have never had to do that. So how does that work? Especially with relation, they're going to wonder about like, can I plead the fifth now that that I'm under oath? How does that work?
So being under oath is, I mean, if you've seen stuff about courtrooms on television, it's really like what you see in a courtroom. You raise your right hand and the reporter's going to say,
Do you solemnly swear or affirm that everything you say will be the truth?
And the only correct answer is yes.
Have you ever had somebody say no?
No, but I've certainly had lots of people who didn't take it seriously. In other words, they lied their way through the deposition.
Oh, good Lord. Okay. And I mean, is that a common occurrence where you have to wrangle in clients and let them know, don't lie, you're like, this is under oath, it's penalty of perjury?
Yeah, let me clarify here. When I say people lie their way through depositions, I'm not talking about my clients.
Sure.
Because my clients and I go into these depositions with a very clear understanding of how they should behave, how they should answer questions. Mm-hmm. I'm talking about, for example, the driver of the other car that caused the crash.
Gotcha.
And I've been doing this for 39 years, and I am really used to being lied to, and I pretty much know when they're lying to me.
Do you think that they are lying because they don't understand that at the end of the day, this is really going to come down to their insurance policy and not their house? Like, do you think it's an element of fear that really induces them to lie about what's happening in the case?
I honestly believe that most of the lying that I hear from the other driver is because they cannot handle the idea that they have caused these injuries to another human being, that it's their fault that this person has suffered the way they have. So I say they're lying to me. They're kind of lying to themselves, in my opinion, because they don't want to be responsible for this horrible thing that happened to the person that I represent.
Nobody wants to be the villain. Everybody wants to be the hero. That makes sense. We talked a little bit about you talk to your clients, you make sure there's a very clear understanding, don't perjure yourself, tell the truth, etc. How else do you prepare clients for their depositions? What are the steps that you would take?
I try to make it as easy as possible because it really should be easy. And the way you make it as easy as possible is you don't sit there and worry about,
Where's this lawyer trying to go with this deposition? What is he or she leading up to with these questions?
don't worry about that shit. Just sit there and listen to one question at a time. and just take that one question for exactly what it is, give an answer, and then stop. Your job's done for the moment. Wait for the next one, do the same thing. If you do it that way, depositions really aren't that difficult, aside from the fact that I know they're stressful on folks.
Let's say I'm in a deposition as a client, right? What am I allowed to say? What am I not allowed to say? How should I be answering those questions?
In depositions, I mean, you say allowed to say, not allowed to say. There's no judge there that's going to smack you down for saying the wrong thing. So there's really no rule on what you are allowed to say. I mean, if I represent you, I sure as hell hope you're going to limit your testimony to what you're asked.
Sure.
That's the big one for me. But truth be told, you can say damn near anything you want to in a deposition.
Fair point. If you have additional questions about testifying under oath, comment below and we'll add it to our future Q&A sessions. How long do these depositions take?
It varies. I mean, my rule of thumb is the older the lawyer, the shorter the deposition. It's not 100% true, but it holds quite true. They just tend to go into a lot more fine detail about things that really don't matter. And I think it's mostly because they're young lawyers and it takes a while to get a sense for what you really need to delve into. So I still haven't answered your question.
How it goes.
How long does a deposition last? If you've got an experienced, older insurance defense lawyer taking your deposition in an injury case, probably an hour to an hour and a half. If it's a much younger lawyer, you're probably looking at a couple of hours. But then let's flip sides the table. If it's me taking your deposition,
Sure.
In other words, I'm taking the deposition of the other driver.
Right.
My depositions of those people, a lot of times don't take any more than 15 minutes because I just want to know what they did, why they did it, what they saw, what they heard, and who has knowledge. I don't give a shit where they've worked. I don't care where they went to school or what degrees they have. I don't care if they're married or single or how many kids they have. I just want to know what they know about the crash.
So is there a reason that the insurance companies do care about some of those other categories? Like loss of income, it makes sense. You got to know where they work, right? But where they went to school, some of those innocuous background questions that are probably never going to be present at trial, is there a reason they're asking those?
Yeah, I think, and again, it's legit that insurance defense lawyers ask a lot more questions about a lot more details than, for example, what I would.
Sure.
Because some of those things do matter to them and possibly to a jury. And like you brought up, for example, loss of income is going to be one category of damages. So isn't it enough to just figure out how many hours they missed, what their rate of pay was, and call it good? Yeah, that's kind of what I think. But, to be fair, and especially for somebody who, let's say, is not even working yet.
Sure.
Now, what their education and their past job history is could matter because maybe they can never go back to the job they were doing at the time they got hurt. So now you need to know what they're qualified to do by way of experience and education. So yeah, it's legit.
Fair enough. Is there a particular dress code for these depositions that you would advise your clients to adhere to?
So my advice to my clients is probably different than what lots of lawyers tell their clients. I mean, look at what I look at right now.
Yeah.
This is what I look like in a deposition.
Fair enough. Fair enough.
And I tell my clients, look, man, don't worry about putting on a suit or getting all dressed up. Just dress casually, dress in something you're comfortable in. I mean, I remember back when I was practicing in Fort Dodge, and there's a lot of workers that I represented that worked at the gypsum mills.
Sure.
Don't show up with the dust all over you. Wear clean clothes. That's really all I care about.
Now, out of curiosity, are depositions typically just transcripts at the end of it, or do they do video footage of them typically? Which do you see?
More often than not, it is just a written transcript, or what's a written transcript? Think a book, a booklet. It's literally every question, every answer, every word that is uttered during the deposition unless somebody says off the record.
Gotcha. If it's a video deposition, do you want the dress code to change a little bit in case it gets played in court?
Okay, so the dress code for me would still be the same because I'm not going to be on the camera. But yeah, if my client is going to be in a video deposition, then I'm going to tell them to dress more like I would tell them to dress in court. Which again, I'm not going to tell somebody to wear a suit. I learned my lesson on that one back when I was a young lawyer.
Oh,
I told a client to wear a suit or a sport coat.
sure.
And he showed up. I mean, he did his best to do what I said to do, but this guy was 45 years old and he was wearing the sport coat that he wore for his senior picture, which in other words didn't fit him. So that's when I switched off to wear something that's comfortable because suits are less and less common these days. A lot of people aren't comfortable wearing them.
Sure.
So if you don't normally wear a suit, I don't want you wearing a suit in your video deposition or at trial because you're not going to be comfortable and it's going to show. So dress comfortably. If it's a video deposition or trial, I'm going to tell them to dress maybe like you would if you're going to a wedding or a high school graduation or something like that.
Sure. Not, sweatpants.
Right.
Let's say you have a client that needs a break during a deposition. How do they state that? What do they need to do?
That's a really good question because, we've already established that these depositions often take anywhere from 1 to 2 hours, sometimes more. And I try to remember to tell my clients before every single deposition, this is not a test on how big your bladder is.
Right.
If you need to take a break, just say so. Because there's no rule, you're not a captive. If you got to pee, just say, hey, can we take a break? And the other lawyer's going to say yes. They might say, yeah, sure, just let me get an answer to the question that's on the table right now, and then we'll take a break. Sure. So yeah, you can take a break anytime you need to. Another thing is, some people, for example, let's say that you've got a really, really painful low back, and the thing that's worse for it is sitting for very long.
Sure.
If you need to stand up to be comfortable, stand up. You don't need to ask anybody's permission. Just stand up. Just don't make a show out of it. But if you need to stand up, stand up.
Gotcha. And if they need a break, not for the bathroom, not even to stand up, they just want to talk to you and clarify something, how do they go about that?
Exactly like you would if you got to go to the bathroom. You just say, can we take a short break, please?
Okay, fair enough. Now, what happens after the deposition? What are the next steps that you tend to see after these depositions, specifically in personal injury cases?
I look at depositions in two different ways. One is my clients are auditioning for settlement. In other words, the insurance defense lawyer is sizing them up for what kind of a witness they're going to be, how believable they are, those types of things. And the other is it's also a dry run for trial. I mean, that defense lawyer is asking these questions because he or she does not want to have to ask a question at trial that they don't already know the answer to. So they're going to ask everything that they think is even remotely relevant to your case during that deposition. So it's not only an audition for settlement, but it's often the last step that is taken before a trial happens.
When it comes to the information itself, the transcript, who has access to that after the deposition? Is it public? Is it private? Who can see it? When can it be used?
Well, it's absolutely private. I mean, the shorthand reporter that transcribes the deposition is going to, well, I mean, you got to pay for it. You got to agree that you're going to pay for it, but she's going to then provide both lawyers with a transcript of the deposition. And then I routinely provide my clients with a copy of their transcript because, of course, I want them to be able to refresh their memory as to what the deposition was like and what their testimony was before we go to trial.
And given that deposition may have lasted 3 hours, it's pretty handy to have a piece of paper telling you what you said.
Yeah, I mean, I can't overstate the importance of being familiar with what you've already said about your case before you end up in a courtroom in front of a jury, because the last thing I want is for my client to get crossed up by an insurance lawyer who has them contradicting something that they said in their deposition.
That makes sense. I mean, in both scenarios, both deposition and trial, you're under oath. So you need to be saying the same thing on both occasions because, again, we have the perjury issue potentially, but also it just looks inconsistent to a jury, right?
Yeah, I mean, hopefully being consistent between the deposition and trial testimony is effortless because you're telling the absolute truth. But in reality, I mean, things that require memory, like how fast do you think you were going, or what did you do? When did you see this doctor? How many feet were there between you and the other car when you first saw it? Things like that. What you say at a deposition is probably going to be an estimate in the first place. And by the time you get to the trial, the estimate might be different in your mind, and it might be totally in good faith, but that'd be an example of something that might come out differently at trial. That's best to have access to the transcript to your deposition to minimize the chances of that happening.
What kind of cases need depositions? Is it all of them? Is it some of them?
Pretty much all the cases I handle. I mean, we just do civil law injury type cases, but it is extremely rare that I have a case that doesn't involve depositions, because it is also extremely rare that I have a case where I don't file the lawsuit. So once the lawsuit is filed, the clock starts ticking. Most of them end up in depositions. The ones that don't are the ones that settle before you get that far. But the percentage of overall cases that get settled between filing and deposition, I'm not prepared to give you a statistic that I have any confidence in, but it's definitely well under half of them.
Makes sense.
Probably well under 25% of them.
So between depositions and on the prior episode, we talked about discovery. Basically, it's laying out the playing field for both parties. It's saying, here's where each person stands, and here's the relative strengths and weaknesses of the case. So when you finish depositions, you finish discovery, that tends to be the ripest time for a potential settlement, because the only thing left tends to be trial. Is that correct?
Yes. And again, I might have all the information I need to offer settlement for one of my clients before the depositions happen, and actually I often do. Mm-hmm. But quite often, once I've made that settlement proposal, the insurance lawyer then wants to take my client's deposition because they want to measure them up. And they want to report on that to the insurance company before they recommend how much they should settle for. And
let's not forget those sweet, sweet billable hours that they get to charge that insurance company.
Well, those folks work by the hour, unlike us. So, it definitely involves their time, and I'm assuming a bill that goes to the insurance company.
Fair enough. Fair enough. Thank you for joining us today. If you've enjoyed this episode of the Biker Rebellion, make sure to check out the next one. Go ahead and click that subscribe button below. And until next time, speak truth to power. Brought to you by the Biker Lawyers. Injured? Ride with us.